Your Honors, the respondents' arguments are flawed for two particular reasons. First, the Clean Water Act is not a public welfare statute. And second, the respondents' reliance upon 1503 in regards to the interpretation of 1512 is not supported by the case law nor its statutory construction. Turning to the first point, Your Honors, if this court applies its standard from Staples versus United States, this court will find that the Clean Water Act is not a public welfare statute because the dangerousness, first of all, the dangerousness is not dispositive to be categorized as a public welfare statute. Instead, this court should look to the severity of the penalties. Criminalizing a broad range of ordinary industrial and commercial activities is not consistent with this court's narrow interpretation of what constitutes a public welfare offense. And second, the respondent heavily relies upon Section 1503 of the Obstruction of Justice chapter in Title 18. However, that is misguided and misconstrues the analysis. This court in Arthur Anderson, in particular, in a footnote when its analysis of corruptly persuades, noted that Section 1503 only contains one mens rea offense, and corruptly within that statute is very much present and represents the only mens rea. Here, corruptly persuades is one of two mens reas, and any analysis from 1503 is not analogous to this case. The respondent relied upon United States, Cole versus United States, as well as other cases from the 60s and 70s underneath 1503. Those cases were dealing with a statute that was much broader in the spectrum. Here, we're dealing with methods and not motivations, and therefore, in this situation, Mr. Millstone did not corruptly persuade Mr. Reynolds to withhold information, and therefore this court should overturn the 14th Circuit decision and find that Mr. Millstone did not violate the Clean Water Act or Section 1512.